the electoral law requires that for you to file a petition, you've got to be a voter. Only a voter, a registered voter, can file a petition in courts, which means it's got to be a natural human being who has got a vote in that election. It also, of course, follows that to participate in the election, you've got to also be a voter, which is why it's only natural human beings that were involved in this case, and it was a huge amount of courage that Gladwell and Zahid put themselves forward, and of course they have received an unfair amount of political vilification for the decision they took on behalf of a very large number of colleagues, but we stand with them and we stood with them in relation to that petition, and I would like to continue saluting your courage, Gladwell, in the things that you've done and continue to do for this country. Now, so those were the 3 petitions, and the court had just the 14 days that are allowed by the Constitution to go through the process of hearing and giving a decision. The effect of having those 3 petitions, I mean, the respondents, basically defendants, in the 3 petitions were Uhuru Kenyatta, William Ruto, IEBC, and the chair of IEBC. And then later on, the Attorney General also applied and was allowed to participate, and he participated on the side of the Electoral Commission and Jubilee and so on and so forth. So in effect, we had 2 sides in court, in substance, whatever their labels. We had Raila Odinga and his team, and we had ourselves, and against this much larger team in court. So those were the practical divisions. The IEBC, which is an important practical division, took the side of Jubilee, of Uhuru Kenyatta in every respect in the court proceedings. And that is an important thing in the way that the balance of power was exhibited in the actual proceedings in court. At the beginning, the court ordered a scrutiny of the results. Gladwell has talked about the fact that it is unclear what happened to the outcome of that scrutiny. Our information is and was at the time, because we participated in the scrutiny, all the available Form 34s were scrutinized. The report that was made to the court falsely concluded, it was a false report, that only a part of what was available for scrutiny was actually undertaken. Because the court never allowed a session to discuss the findings of the scrutiny, the issues we had about the false reporting about how the scrutiny had happened never got any play. And the results of the scrutiny, however partial they were, never got referred to in the judgment. And even in their partial state, even in partial state, the outcome of the scrutiny was still adverse to the IEBC. So those are many important different points that I make. They were adverse, they were full but misrepresented as partial, and even in their alleged partial nature, they were still sufficiently and gravely adverse to the IEBC. But we still don't know, as I've said, how the court treated them, because they were not reflected in its judgment. So the question that arises is that huge enterprise of scrutinizing results that was ordered and took place at KICC, nobody really knows what it ever came to and what it was for. Now, in the course of the hearings, there were many interlocutory applications, interim applications, to use English. The first was by Nazlin Omar. She wanted to join the proceedings in some capacity. The Jubilee side, which includes IBC, opposed her joining the proceedings. The court rejected her joining the proceedings. The Law Society was next. It applied to join the proceedings. We had no problem with the Law Society joining. The Jubilee side, including the IBC, had problems. The court refused them to come in. Third was the Attorney General. He wanted to come into the proceedings. We had problems with the Attorney General coming into the proceedings. The Jubilee side, including IBC, had no problems with the Attorney General. The court allowed it. Next was Katiba Institute. Katiba represented up there by our brother Waikwa. We wanted Katiba to come in. We had no problems with Katiba. The Jubilee side, including IBC, had problems with Katiba. The court did not allow Katiba. The next application was the affidavits of the 900 pages of additional evidence that Raila Odinga wanted to put in. Jubilee had problems with those affidavits. We had no problems with those affidavits. The court blocked the coming in of those affidavits. The last was the computer logos. IBC applied, Raila Odinga applied that the court compels IBC because of the problems, the allegations about shared servers between IBC and TNA. The only way it could be proved or it could be disproved that the two were sharing a server was by IBC making certain disclosures about its computer computer logs. Now, so we had no problem with the IBC being compelled to produce computer logs. The IBC had a problem with it. Jubilee had a problem with it. The court had a problem with it. So in sum, there were 6 interlocutory applications. Those that Jubilee opposed with IBC, the court also disallowed. Those that the Jubilee supported, the court, those that Jubilee opposed, the court disallowed. Those that Jubilee wanted, the court also allowed. The effect is that, okay, and then I also speak about the alternative petition by Dennis Itumbi and Moses Kuria. We opposed that petition, and we continue to oppose it, and continue to oppose the kind of legal reasoning it produced. The IBC, importantly, the IBC, of course, opposed our petition, but importantly, it did not oppose that petition. And that petition, the court allowed. It is the only petition that succeeded. So what is the totality of what was going on or what happened in court? Everything that Jubilee IBC wanted, either procedurally or substantively, it got 100%. Everything we wanted, procedurally or substantively, we lost 100%. That should give you a sense of how one feels about how that court deployed its power. In between we felt that the court failed to give our alternative petition the respect we thought it deserved. We had less time to present. The court failed to protect us from bullying by the Jubilee lawyers, and the court did not discuss or refer to the petition in its judgment whatsoever. There is one short, small reference in the petition, in the judgment of the court, to the effect of the main petition, characterizing the Raila Odinga petition as the main petition. We did not know, it never became clear to us as to what time we became the subsidiary petition. So the court treated us as Cinderella, which is the same status that the Jubilee lawyers had given us throughout the proceedings. We were tolerated rather than accepted. The second point to make is Jubilee lawyers, rather than the court, were in charge of the proceedings. They controlled what came in and what happened. The power of lawyers, the lawyers from the floor were running things rather than the court itself. They were running the court, they were saying, allow those ones, don't allow those ones. And that is what happened from the beginning up to the end. The third point is, given how then the lawyers were in charge of the court, and I've given you the list of who are on the other side. Because Uhuru Kenyatta had his lawyers, they spoke in his defense. There were a lot of they claimed and were validly legally allowed to participate in the proceedings. William Ruto had a different representation. They also spoke. IBC had a different representation. They also spoke. The chair of IBC had a different representation. They also spoke. The Attorney General had a different representation. They also spoke. Now, the preponderance of all these people speaking to one side drowned out the other side. So there was a lack of equality in terms of who was speaking. They had very many, because they were defending the same interests. They had very, very many turns in between and among themselves. And the decision, for example, that the Attorney General will participate as amicus curiae, supposed to be an independent assistant to the court to help it to come to adjust a decision on the issues at play, which is the basis on which he was allowed to participate. That was thrown out of the window immediately. He started participating, and he participated vigorously and robustly on behalf of only one side. So, given how little time there was in the actual proceedings, and time became extremely precious, and then they hogged all of it, it also then became very, very difficult to have the alternative view about whatever needed to be said, being given the same levels of prominence in court as what was presented before by the Jubilee IBC alliance. So we are in that moment again, and we have another election petition. One hopes that looking at what happened in 2013, there are some lessons that the court and everybody has learned. I think the first lesson is we hope that the court will have the courage to take control of its own proceedings rather than allow those to be controlled by any one set of lawyers. Secondly, it is felt that if there is no cheer in the elections, and the elections have failed in exactly the same way as the previous two elections that failed, if the court as the place of last refuge does not give the kind of remedies that people who go there and hope they can get despite all the odds, then it becomes very difficult to see why people are going to continue investing in elections as a means of peacefully changing leadership and moving on society. Thank you very much.